seems like just a few days ago that we were talking about this FBI letter. And I think that's because it was just a few days ago that we were talking about this FBI letter. But there were a lot of comments on it on YouTube and Twitter and stuff. And I think it would be worthwhile to show you the rest of the information that I do have on it so you can use it for the judgments you're making. In my opinion, as I think I alluded to in the last video, as it stands right now, it seems to me that this letter is not what it was purported to be and was a device that was useful in the custody proceedings. And that's really good for Manson in his case, obviously, because they're saying this was not accurate information produced to the court. In fact, they say that it was false information submitted to the court. That's what you want if you're in his shoes. The downside for him is, at least as the evidence submitted is, unless I've missed it and nobody's shown me something that I've missed yet, there's nothing in the evidence that says this letter was used in this alleged recruitment scheme. Yeah, I get it. It's part of it. It's, the narrative, etc. But Wood states in her declaration that this was only exposed to the child custody process. She didn't release it to anybody else. There may be people who haven't come into the record yet who would counter that, but I just haven't seen that in the declarations, unless I've missed it. I'm not talking about people who may have said it to other people outside the court. I'm talking about what the court will consider. So currently it looks like, this thing is not directly tied into the case so well. And I mentioned they said upon information and belief in the complaint, and I think that's why that they did say that. And looking at the forecast of evidence Manson wants to get from his proposal to the court for limited discovery, there's not somebody listed on there specifically going to say this FBI letter was given to me. They might say that. Michelle Meyer could say it. He could get it, from the defendants that it was passed out to people. I just didn't see that bullet point. Again, a lot of documents in a lot of cases, and I have real stuff to do too. So I could have missed it. I just haven't seen that yet. There are some people who are pro-Wood who make the contention that this letter is no big deal. It was only used in child custody. It really wasn't presented to be an official letter. There was a criminal investigation, so what's the big deal? Manson was under investigation, so the letter is meaningless. And there are people on Manson's side who say, well, this letter was fake. It was used to lure people in to make accusations against him. And so everything in this letter is fake, including when the father tried to call the sergeant. He couldn't have got that person. It's all made up. And I believe it's pretty clear that neither one of those contentions are going to be correct based on the evidence of both parties. I think, Wood and Manson could get together for one moment and say, guys, none of that's what it actually is. You'll just have to wait and see. And if you're polarized completely on this, I guess, whatever information does come out, you can just filter it right through that narrative and it's okay. But this letter still remains somewhat confusing to me. It appears to me that it was a device created by somebody to use in this custody proceeding primarily. I don't know if it was ever used outside of that. And it does not look like it was what it was purported to be. And that makes it significant for Manson. I think the defense has the good argument that it's not really a subject to this case because it wasn't used in the recruitment. Manson's going to need to shore that up. But let's look at what the evidence is. We already went over a lot of it in the last video, and I'm going to pour some more out here. And hopefully we'll be able to think about this a little bit. If you think about an old show like Star Trek or even the X-Files, where you have Mulder and Scully, and you've got one person who's super rational and one person who's like conspiracy oriented and thinking about what's the stuff out there we don't have the evidence for, the old I want to believe poster. And in Star Trek, super logical Spock, the doctor who's all emotional, and the captain who's action oriented and tries to synthesize that. They take a complete way of thinking and split it apart and then present this to a situation, and then the interaction becomes how do you balance these thought processes. And it's really entertaining and it's pretty good. But you can do that. You can have a hit season in your own mind by emulating that yourself, by just challenging yourself. You don't have to pay any streaming service. You can challenge the way you think and think, well, if someone were sitting across from me who was on the other side of the case, what's their best arguments? And think about what they're doing. And you can have your own show there, as many episodes, watch it, binge it, however you want. And the real evidence in the case, well, that's the situation you're presented with to apply your thinking to. So let's look a little bit at what the further evidence in this case is. In April of this year, Evan Rachel Wood filed a declaration in the current case, Manson against Wood and Gore, and in it she did mention this FBI letter. So, of course, it had been the subject of allegations by Manson in the lawsuit, and she files a sworn statement to explain the parameters of that letter. And she's an entertainer, and she says she's an actress, and she says she's a singer, and I contend, based on this paragraph, she has some talent at tap dancing. So she says, I did not distribute the FBI letter outside the scope of my custody dispute with Mr. Bell, did not provide a copy to Mr. Warner, and I did not leak it to the press. I did not fabricate or forge this letter. So she's making straight declarations to the court that go against Manson's accusations against her. She's saying, I didn't distribute it, so therefore it's not used in this recruitment situation, and nor did I even make it. So she's got some evidence on the record, whether you believe it or not, that go against what Manson's allegations is upon information and belief allegations are. So where's his evidence? Upon information and belief's not going to get it for the anti-slap motion. He's got to have something in evidence. But then I contend the curtain comes up and the performance starts a little bit when you see this part about when I received a copy of the FBI letter, a copy of it, not the original, and when I submitted it to the court, I believed it to be authentic. I did not knowingly make any false statements of fact. Again, these are past tense. I believed it to be correct. I didn't knowingly make. So again, does she currently believe it to be authentic? It doesn't sound like it, does it? So maybe some of these allegations she made in the declaration at that time, she's going to have to admit now appear to be incorrect, right? She's going to say she didn't know it then. But still left to the great mystery and apparently waiting for the season ender is, who gave you the copy of this FBI letter? Who gave it to you? It'd also be nice to know when and how, but who? And that question is unanswered in this April declaration. And I believe there's a reason for that. Again, you look at what these people submit to court, what they say, and when you believe they have relevant information and they're not telling it to you, I think it's fair to pay attention to what they don't say. So that's her most recent stance that we know of on this letter. And this case, of course, was subject to the case with Wood and her child's father was subject to various custody dispute situations going on in California and also in Tennessee. The father filed in California, the mother filed in Tennessee, and both of them wanted the state that they chose to assert jurisdiction over the matter and decide it there. And Wood, since she moved to Tennessee, she was the one wanting it, held in Tennessee. So there were these two actions. So in the California action, we see more about the letter than we do in Tennessee, which really was limited more to the jurisdictional issues. And in California, both parties had more to say about it than they did, I think, in Tennessee particularly. So let's see. The father brings it into the picture. Let's see what he says. First, he sets the stage that his child was not provided to him at a time in December when they had previously agreed for several days. And then when he tried to communicate with Wood about it, she wouldn't answer his calls or texts, and neither would her mother. It wasn't until he reached her assistant, he says, that he finally got something from Wood, which was on the 22nd of December when he received an email saying she was going to stay in Nashville, that she was a witness in this investigation, and it was for the safety of her and the child. On the 23rd of December, here comes the letter. And he says, I received a letter from Evan on December 23rd, supposedly from law enforcement personnel connected with the investigation. It was sent through Signal app. He says the first one he got had Ilma Gore's name at the top. Then he got it again, and it had Evan's name at the top. So this, supports Warner's allegation, Manson's allegation, that the two of them in some way collaborated on this letter. I mean, what is Ilma Gore doing, sending this letter by Signal app? Why isn't Wood doing it? So then he says Evan deleted that post. The letter was not on any kind of department letterhead, and the agent and the named department that he found on the letter, he couldn't find them through Google. And I know some people have said, well, when I Google that, I do find it. And I'll quibble with that for this reason. Not aware of any department in the FBI called the Federal Violent Crimes Department. Yeah, they have a Federal Crimes Division or something like that, but that's not a department. And, my interaction with police and federal agents and my own background in the military, these are all kind of the same in that when you work for an organization like this, you know what you work for. you would never say, if you were in the 82nd Airborne Division, that you were in the 82nd Airborne Company or the 10th Special Forces Brigade. You're not going to do that. That's somebody making something up that doesn't know what they're talking about. You will have the correct name of who you work for on your own letter. And would you sign it with just your name and not your title on it? So I support him on this, that was apparently bogus and is bogus. So he notes that the letter says that the safety of the family was of the utmost concern, but he notes the letter didn't say anything about any danger preventing Evan from allowing him to spend time with the child in Los Angeles. And remember back to that text message that Breitengore submitted in her declaration that is evidence for Manson, showing a text from Wood to Ilmagore with a draft that appears to be an early draft of this letter, specifically actually addressing the fact that you ought to get out of Los Angeles. But that wasn't in the letter that ended up being sent to the father. Who changed that? Who actually produced this letter? We just don't know, but he's correct. The letter that he saw, it doesn't say you need to be out of Los Angeles or you can't have the child in Los Angeles. Those things are not in this letter. So he says he tried to call his agent for 2 days. That wasn't happening. Finally got a text from somebody who we later learned was Michelle Meyer that was a different person, and sent another number that didn't work. But conspiracy theories aside, he says he contacted one of the law enforcement agents on the letter. And this was Sergeant Jeffrey Walker. To some people, he must be imaginary because otherwise that could possibly support part of Wood's claim. But I don't think he's imaginary. I checked myself and found records from a few years ago connecting him to the job title that was written on the letter, doing what the letter said he does, with the actual phone number that was provided on the letter. I also checked the district attorney that was provided on the letter. That's the real district attorney for that section, works in that area. That was his actual email address. I didn't call that number because I'm not calling that number. But from records that I found on the internet, both of those contacts, the handwritten contacts, were legitimate contacts. It was the typed contact that was incorrect. What the father says was discussed when he reached this law enforcement officer is one of those cool paragraphs that's likely to disappoint both sides of the case. On one side, because unless you just believe his father's an idiot and was totally bamboozled, and that's possible, he actually did reach a law enforcement official that was listed on this letter. And this law enforcement official said there was an investigation. It's terrible news if you want to believe the letter is completely fake and that there was no investigation, because the father says, yeah, I talked to a law enforcement official who said that. But you're going to be disappointed if you're on the other side too, because of what he says about this investigation and what an investigation means. I contacted another one of the law enforcement personnel Evan directed me to, Sergeant Jeffrey Walker. He informed me that the criminal investigation Evan was involved in had been going on for quite some time, would likely continue for quite some time, and it had nothing to do with our current custody situation. He did not indicate that there was any present danger to our son. He said the case was now with the FBI and advised me to get legal counsel with respect to custody issues. So this testimony would go to show that law enforcement had some kind of investigation going on with Wood, and that likely involved, of course, Manson. But what it doesn't say, according to the father, is that law enforcement said there is a danger to your son, that Manson's a clear and present danger to your son, and you need to take the mother's advice and get your son out of this area. He says it was the opposite of that it's something that had been in their files for quite a while, likely was going to continue to be there for quite a while, nothing that was immediately impacting their custody situation. So everybody gets to be disappointed with this one. And I think that's a comment on investigation. I mean, what is investigation? Aha, there's an investigation. That doesn't mean Manson did anything, right? It doesn't. It means what it says it means, investigation. So we know that people complained about him, right? I mean, certainly Wood did and some others did. Why would it shock anybody if law enforcement were looking into that? Why resist the notion that complaints had been made to law enforcement that one could call an investigation? That's not the same thing as they've indicted him or that they've proved anything against him. It's just an investigation. That could be on bad tips. That could be rock solid evidence. You don't know, so why make an assumption one way or the other? So to me, the only relevance that it has, if there is a quote-unquote investigation, is if you're hanging on Manson's allegations that part of the recruiting process and getting women to make false accusations was based on the lie that there was an investigation. And if you need that, I understand why you don't want to admit there was one. But there does seem to be evidence that there was, or at least that the parties involved in this case, because the father had no reason to back up the mother here, they're fighting in a lawsuit, that the parties involved in it believed from their interactions with law enforcement that what was going on could be termed an investigation. We'll just have to see how that one goes a little bit. I think that one's muddier than really either side would like it to be, which is how I like it to be, because I like to think about these things from both sides. So that's how the father gets it into the record. And then his attorney in California makes a memorandum, a brief to the court, relying on his client's statements, and speaks to this letter. And goes a little further than the father does. Kind of interesting. The attorney notes that Evan did not appear with the child for the scheduled exchange in December and didn't answer the calls or texts. So that sets the stage for this letter coming on board. Her response was cryptic and evasive. I like it. But here, let's get into it. Evan sent Jamie on a proverbial wild goose chase, providing a suspiciously vague letter purportedly from law enforcement and erroneous contact information for law enforcement personnel. Yeah. Once Jamie correctly identified the law enforcement officials Evan seemed to be directing him to, he was giving little further detail. The law enforcement personnel did inform Jamie, however, that whatever was happening with the criminal investigation should have no bearing on his ability to exercise custody of their son in Los Angeles. Evan's story defies credibility. Either the criminal investigation is placing her in danger, in which case the child should be with the father, who, in theory, Manson has nothing against, or she has invented or exaggerated any potential danger and is withholding the child from the father to satisfy her own whims. So that's his lawyer's take on that. And I think you could conclude from the evidence that this letter was an effort by her to magnify the level of danger that she was experiencing to try and win this case. Now, if she did manufacture this letter or had someone participate in it, that's clearly wrong. But it doesn't mean that she didn't believe that she was in danger. You know, you're gonna have to get further into that, because she keeps saying it. She said it in her declarations then. She said it in her live testimony in Tennessee. And then she has said it in the declaration in this current case. So you're going to have to come up with some evidence that she didn't think there was an investigation and she didn't think she was in danger. So turning to Wood's declaration in California to rebut what the father is saying, we see her continuing on with this theme that she was in fear and that she needed to get her son out of town. She says, "I'm afraid that he," now we know she's talking about Manson, "will seek retribution against me for testifying by harming me, our son, or members of our family." And she digs into this in the next paragraph. "I was advised by criminal investigators that my and my family's safety was at risk." Then she talks about the letter. Already talked about that in the last video. But below that, she says, "The investigators made clear to me that our son could easily be targeted by the alleged offender, who is Los Angeles based and who is not in custody at this time." So she's making the case that investigators told her that she was unsafe, that her family was unsafe. And remember, the first draft of this letter she had, I shouldn't say first, the earliest one that we saw, says, you know, you're not safe in Los Angeles, basically. But the newer, watered down one that became part of these proceedings, it doesn't say that. So obviously, the court, I think, would consider, if law enforcement personnel are saying you should get out of this area and remove the child from this area, the safety of a child is a big deal to the court. So if one had come and sworn in and said that to either judge in any of these cases, that would be a big deal. Even having it as the mother's mindset is also a significant deal, because she's trying to care for the safety of her child, and the court's going to look at that and say, well, how reasonable is that under the circumstances? So this is what she said about it, you know, that she got this letter from a representative of the Federal Violent Crimes Department of the FBI, and she had been told that it was unsafe there. So she lays out these facts. Then her lawyer runs with it, as lawyers do. So again, in the California proceeding, the lawyer makes these claims, because they went further in California, it seems to me, than they did in Tennessee, because I don't think that letter made it into evidence in Tennessee, and it really didn't become important anyway. But again, back to this. Her lawyer's side, that Evan, while a minor, was the victim of torture, rape, and pedophilic grooming by Manson. And the danger to her as a key complaining witness and those around her, and the inevitability of the criminal investigation becoming public knowledge, she was advised by criminal investigators that her safety in Los Angeles was at risk. So the lawyer's basing that on the declaration that she made. The public figure in question and his large following of rabid fans present the risk of serious harm to her and her child. Now, okay, he's one thing because he's in Los Angeles, and I guess he wouldn't bother to travel to the new place she's going if he was really keyed up to harm her. And he has these rabid fans. Are they all out there where he lives? I mean, do you think he'd have some rabid fans in the new city? So this, to me, is a little overblown, even if it were true, especially because the father can make the case, which he did, that if you're this big target because of this investigation, let me take care of our son until this investigation's over. Why wouldn't you leave him with me? Because I'm not testifying against Manson, so he's not after me. There's some logic to that. And then the attorney says, to punctuate the seriousness of the situation. So let's consider this punctuated. Evan was provided with a correspondence from a representative of the Federal Crimes Department. So this kind of mimics the declaration, but it's different. From a representative of the Federal Violent Crimes Department, a Los Angeles Deputy District Attorney, and a sergeant for the Special Victims Bureau of the Los Angeles Regional Human Trafficking Task Force, wherein they wrote. Now, in her declaration, she didn't say that she got it from these three people, but she did change from kind of individual to they, though. I remember talking about that in the last video, noticing that. So this attorney says, wherein they wrote. And that, to me, clearly implies these three people from different law enforcement entities wrote to her this letter. There's only one alleged signature on it, and that's from this agent that didn't sign it. And then, of course, all in bold, etc., is the letter, the language from this letter. And then bold and underline. Look, what else could you possibly do? You can't make it 3D. The criminal investigator's advice to remain in Tennessee has proven to be extremely prescient, given that in a recently recorded phone conversation between the alleged offender and a third party, he indicated he knew where the complainants lived and he intended to retaliate against them. In light of the ongoing criminal investigation, though, she will not be filing this recording with the court. Okay, but you're going to tell them about it? Whatever. So she's part of a big federal investigation, credible threat to her family. It changes a little bit down here from rabid fans to avid fans. I guess the avid ones they're like, yeah, I go with Manson, but I'm not going to get in my car and go do anything. And the rabid ones would actually show up and say something to you. I don't know. My point of this is the brief of the attorney in this case really pushes this letter and the alleged comments surrounding it. Investigators told me that I'm not safe where I am. And in fact, it says here that criminal investigators' advice to remain in Tennessee. They all three said you should remain in Tennessee, but they didn't put that in the letter. I mean, how do we know that's true? So we're deep into some hearsay situations here. I'm not even sure she said that in her declaration. Maybe she did. Anyway, the attorney said it, and there it is in writing and submitted to the court. So Wood and her attorneys leaned pretty far into this letter in front of the custody court in California. They did some in Tennessee, but I feel like from my reading of the transcript, they didn't push it that hard. They did get, into talking about some death threats, I think, that she got on Instagram. They didn't get into the recording. In the end, in that case, the judge was really only looking, do I want to assert jurisdiction or attempt to assert jurisdiction here instead of California? That's what he was looking at. And while he was skeptical about how much time Wood might spend in Los Angeles, he accepted that Tennessee was their home for purposes of what he was doing. But then he ended up saying, nevertheless, California is the right place to have jurisdiction if they're going to take it. And he dismissed, on the 11th of May, he kind of told them that this is their home, yes, but let's see if California is going to take jurisdiction. And on 9 August 2021, the judge did dismiss the case in Tennessee. But from what did happen in Tennessee, we can kind of see the importance of this alleged advice from investigators to get out of town and this letter and stuff, because she does tell the judge in Tennessee that she's alerted to safety issues regarding Los Angeles FBI criminal investigation. They tried to get in, I think, into the letter. They couldn't make that happen. They tried to get into death threats. They got those introduced, I think, maybe more for her frame of mind. And at some point she said she got some of those on Instagram. She heard about this recording. The judge didn't want to get into that. And that's important because she did say when she was answering questions that she hadn't got a recent direct threat from Marilyn Manson. Here's what she says. My question to you is that you have been receiving threats since 2009 from Marilyn Manson. Answer by Wood. The last threat I received from him was in 2014, and I haven't received any more since then, but I have been alerted to his threatening nature. So you can see that once you make a statement like that, you've got a gigantic gap here between the last threat that he made all the way up to now. Now, of course, she says it's because this criminal investigation has started, and he knows, I guess, that, or he will know that she's a witness in that, and he's made statements that these people, I'm going to get these people, is what she says. So he didn't make those directly to her, though. So she's trying to get in this evidence of this, either through the Instagram threats or people telling her about the recording or hearing it, or even more attenuated through this alleged law enforcement letter that doesn't say she needs to move out of state, doesn't mention Manson, etc., but helps, she says, form her basis for why she has this reasonable fear for the safety of the child that everyone should acknowledge. So it seems obvious to me that in the Tennessee as well as the California proceedings, that Wood played this letter up pretty hard, and played up hard what she says the investigators have told her. She played that up hard to show the danger to her child so that she could have the custody arrangement that she thought was appropriate. And now in this current lawsuit, her attorneys say, well, that never got distributed outside the context of the custody proceeding. And they're doing that because they're trying to get inside the litigation privilege. And they're also trying to show that it's not really connected to Manson's claims that it was used for recruitment. They didn't really speak to the authenticity of the letter due to the tap dancing. And I think you can take that more than one way. I get the legal reasons why they're doing it, to reduce his claim, and also maybe have it taken out as a privilege issue. But the other side of it is, if it is fake, and she really, like her attorneys say, this was only going to be used in the custody proceeding, yeah, I never really thought anybody else was going to see it. So if we just go through this custody proceeding and get that done, that's the end of this letter. It wasn't going to be a big production beyond that, and no one was going to check into it further than that. Again, it completely seems ham-handed, because Manson has produced a declaration from an attorney who says that she spoke with the FBI agent who said it had nothing to do with this letter, and the letter has nothing on its face to suggest it was produced by an FBI agent or this department that allegedly exists. There's just nothing there. There's no letterhead. There's no title next to the person. It's crazy. So I don't think it was produced by that. But who did write it? Who printed off the first copy? Who would have done those things to make what Wood is saying under her current declaration literally true? That she received it, that she didn't fabricate or forge it, suggests that someone else did that. And we don't really know who that is, although the assumption is, and I think the allegation is by the plaintiff, that the other defendant, Gore, did it. But we just don't know yet. We're just going to have to see. But how do you square that with Wood claiming at the time I thought it was authentic? She needs to show that she can't say, well, I got it from Ilma and I thought she got it from the FBI. I mean, I guess she could. She could say, Ilma said, hey, I ran by the agent and picked up this letter and I want to give it to you. Is that what she's going to say? That would be pretty interesting, wouldn't it? I don't know. But she's got to say something at some point. And we don't know if it'll be because the judge grants limited discovery or doesn't. I can say that I have seen things that are very compelling to me, that the defense is preparing its own evidence prior to this hearing. And so there may be some things to drop before that. I really am confident of that based on what I saw. Now, whether they actually intend to produce it or not, they'll just make that decision at the time they have to make it. But they're not just sitting there going, well, I guess we'll just see what happens. They have their own things they're working on. And there are two sides to this case. Wherever it leads, we'll see. But even if they don't do something, or it's not bombshell worthy, this limited discovery that Manson is seeking, it would be bombshell worthy, because he wants to depose the defendants and the material witnesses of the case. And that's going to show whether there's merit to what he's saying or not. It'll go a long way to it anyway. I kind of hope it does get allowed, because it will clear up some of the facts of this for everybody's sake, because these are public figures on all sides of this, before the anti-slap motion is heard. So that's what I know on this letter, and how I think it was, and why I think it was created, and its significance in this case. I can't currently imagine there's anything more to know about it until somebody comes forward with some actual evidence that was involved in it. So let's switch gears to a different law enforcement letter that's not the FBI letter. One that, at least, that I hadn't seen before. So we've gone over this in exhaustive detail about this FBI letter and what it did or didn't do in the various cases and how it sets in this one. But in the California proceeding, Wood filed another declaration before the live hearing in May in Tennessee. And I'd originally understood that at the hearing in Tennessee, they were only discussing the FBI letter, but that's incorrect from how I see the totality of the documents, because I think there was another letter that they had wanted to introduce in Tennessee. It still ended up not mattering, but it may be significant for how we see this case. So in April of 2021, Wood responded to what she saw as concerns from the court over the nature of this investigation. She filed a declaration, and she said, at the last hearing on April 5th, 2021, I understood the court was questioning the nature of this investigation. That's the one about the family, the safety, etc. In an effort to answer the court's questions, I obtained a letter from the Office of the District Attorney of Los Angeles confirming the nature of the investigation, and it's attached. The Deputy District Attorney is not at liberty to set forth the details of the pending investigation in writing and encourages the court to contact him for further information. So then attached to this is a letter that has all the things the other letter didn't. It has the person with their title, it has the letterhead of the office they're on, and it actually looks like it was produced by a government official. So now, with a giant plot twist, in April of that year, we have an actual letter from a law enforcement agency that, on the face of it, would seem to be authentic. To my knowledge, it hasn't been the subject of this current lawsuit at all. The Manson versus Wood. So how does it play into it if nobody's bringing it up yet? Maybe it's going to get brought up soon. Maybe there'll be some more bombshells rocking out of this thing. It doesn't change, I think, the analysis on the previous letter. In fact, it probably reinforces it. In the two areas or three areas maybe where that letter was relevant. And one is, did the defendants believe there was a criminal investigation? And I still think that's the case. And I think it's harder to deny that when there is a letter from a district attorney saying, yes, there is an investigation going on. It's not the mystery letter from the fake agent, right? It looks like a real letter. We're going to have to see, and it's going to have to get tested if it comes in. But it continues that line of logic and thought that I had, that the original letter that is purportedly fake was done really pursuant to a belief that this was really happening, that there was an investigation, and that perhaps Manson would get arrested. That the letter maybe was created by somebody who thought reality is moving a little too slow. Let me get this in here and reality will catch up, and it just didn't happen. That's just a theory. Either way, this supports the idea that the defendants did believe there was a criminal investigation all along. So that matters. But maybe it also matters on the pro-Manson side that why did you stop attempting, essentially, maybe, certainly don't have everything. Why'd you need another letter, I guess is the way to put it. Why'd you need another law enforcement letter? What was wrong with the first one you got? It was pretty clear, wasn't it? Had lots of people's names and phone numbers on it. So here's a new letter with a district attorney saying who can be contacted relative to these things, and not a mention of the old letter in this new declaration. So were the gears starting to shift on the old letter even at that point, even at April of 2021, that let's move it on to this new letter? Did the old letter play any further role in that? I don't know. And as we discussed in the new pleadings in the Manson case, Wood has some apparently equivocating language about the authenticity of the original letter, and that she believed it was real when she had it, etc. She doesn't mention this new letter, and neither did Manson. So I wonder what's going to happen with this. But a real law enforcement letter. So we got a real one and one that's contested. Interesting. Thanks.